Good morning, everyone. Let me call this meeting to order. Members of the public, we are grateful for the fact that you have are attending our meeting. Let me begin with the roll call of the commissioners. Commissioner Bluestone,
I'm here.
Commissioner Calderon,
Present. Good morning, all.
Commissioner Sherry,
I'm here. Good morning.
Commissioner Ellison,
Good morning, present.
Commissioner Kazarosian,
Here, present. Thank you.
Commissioner Luma,
Good morning, present.
Commissioner Wynn.
Good morning, President.
We obviously have a quorum. Commissioner West is unavailable to participate in today's meeting. Let me turn now to our executive director's report. Please, Enrique.
Thank you, Madam Chair, and good morning, commissioners. I will, like I have done in the past, share my screen on and present a PowerPoint presentation in a minute to talk to you about the recertification process for I through P that we have begun. And later on, I'll be also telling you a little bit about suspensions, administrative suspensions, as well as a brief budget update as part of my report. So if you give me a minute, let me share my screen. And maybe I should, here we go. And actually, before I do that, I just want to welcome Matt Landry, who is our Director of Standards. That's his first day is today. He's sitting here with me in my office. Since last meeting, we also welcomed Aliyah Spring, our Digital Director, our Digital Communications Manager, joins Cindy Campbell in the communications effort. So let me get right to the report. In your packets, I have a detailed memo of the process, the changes that are different from the recertification effort that happened last year for those officers named A through H. We now turn over our attention to officers with last name I through P, as is required in the statute. And we will begin to start communicating that process in earnest in the next few days and weeks. Just as a reminder, this process is governed by the regulations 555 CMR 7.00. The principles of that process remain the same. Agencies will complete two documents or two. The recertification packet is comprised of two parts. Part one, which incorporates a lot of questions relative to the requirements of the statute, and part two, which is what is referred to as the questionnaire that facilitates the oral interview requirement. We deputize a chief or their designee to conduct those oral interviews and administer that questionnaire, and ultimately attest to the good moral character of the individual officers and fitness for employment as a law enforcement officer. So that remains obviously the same. There's a few changes again that I will summarize in the next couple of slides. There's some updates to the way we ask the questions on part one, and that is to ensure that there's more data accuracy. There were a couple of confusions relative to training last time around because we asked the question that pertained to training in one question. Those are three separate questions now, for example. I should note that part two, or the questionnaire, remains the same. Those are the 6 questions that we ended up asking, or having agencies ask of the officers for the oral interview. Commissioners will remember that we started with 8 and 2 were eliminated as part of a complaint prior to the start of A through H last time around. So anyway, the questionnaire remains the same. Those are the 6 questions that we did for A through H. What's very important to note is that there's a new technology platform. This is our permanent solution, what we have reported in the past. The first time around, we used something called JIRA, which was a portal where people, agencies uploaded information on a template into that portal. Now, this permanent solution, which is ultimately going to be our portal for all things, not just recertification information, but contact information, as well as later on submitting complaints and other reports to post. This is why it's important to note that it's our permanent solution. We're deploying it just in time for the recertification process of I through P. I will note that this information is uploaded directly into the portal. Because of that, we are allowing agencies that will submit 100 information about 100 or more officers to have a data migration option. And I believe there's only about 6 or 7 agencies where this is the case. So we can make that exception, of course. The majority of agencies are around 10 to 20 officers, and all of that information can really be submitted directly into the portal. Like last year, we will begin doing some training and office hours on the portal. I will note also that everybody who had a prior login to the prior software platform will be emailed their credentials for this new platform at around mid-May. Again, we'll start the process of communicating this new process. I am going to be speaking in front of the chiefs at the end of the month. There's a conference coming up as well, where we will have some presence. And again, we will be emphasizing the availability of office hours remotely to have people come in and ask questions as they see fit. I will also note that the way that, as part of this new process, we will be emailing directly the notifications to the officers. We're also capturing, and we believe we already have a lot of information relative to the email addresses of officers. Unlike last year, where we asked agencies to distribute those notifications for us, we're attempting to now email directly these notifications to officers. So we will have a process in which if an officer has not received their notification, they can and should request the status of their information directly to us. However, I will note that those time-sensitive notices, we will continue to copy not just the individual, but the chief and the head of the bargaining unit, as has been our practice in recent months. And by those time-sensitive notices, I mean those who may have been not certified, for example, where they have 21 days to request a review and to respond to the lack of attestation on the chief, for example. Those few instances, we will make sure that others are copied and those notices reached in the individual ultimately, because they're, very time sensitive. So in this sense, the post protocol continues to be to ask the chiefs to help us making sure that these notices are received by the individual. And I'll just give you a quick example. In some instances where maybe the individual is out on administrative leave, if we are simply emailing their work email, it is very likely that they will not have access to that email, and that's the reason why we will be asking for this help in serving some of these notices. But the vast majority of notices will go directly to officers, because the vast majority are going to be recertification notices, or notices in which the individual is recertified. Something different from last year is that Post will verify compliance with training requirements prior to sending those notifications. Last time we relied entirely on what they told us, whether they had completed in-service training or the Breach Academy, if they were eligible or had obtained a waiver from the NPTC to that effect. That ended up being a challenging process to audit, and in some instances we had to correct and send some correction letters. So we are now availing ourselves of a time frame to make sure that we will corroborate all those training requirements before sending those notifications. Again, in the hopes that this will minimize the need for issuing correction letters. This is just a brief overview of the time frame. Is similar to last year in terms of the amount of time that agencies have to respond and upload information. But I will note a couple of key differences. Just as it states in the at the top, we have finalized the new platform. We have tested it with the vendor, and it's working well. We're making sure that there's no issues. We will begin early this coming month to deploy the documents that are relative to this process to be available in our website. We already started to collect attestations for chiefs because those come separately. Any chief that is with the last name I through P, they get their attestation from their appointing authority, and that is continuing to flow into our records. We'll make the portal available on May 22nd, but I will note that, of course, the process for administering the questionnaire and answering the questions for part 1 will be available before that, so that agencies can deploy and interview and deploy that questionnaire well in advance of that May 22nd date. May 22nd is the time when the portal is available for data uploading and input, and June 30th continues to be the deadline for submission. Actually, last year, the deadline for submission was June 15. We have now made June 30th the deadline for submission, and July 31st, the date where we begin to send notifications to officers. It's likely that we will also be sending some notifications prior to that date, but this is what we are targeting as the date for sending notifications. Everybody will remain certified after the June 30th deadline, in which those certifications, statutory certifications, expire, so long as we have them in our records, or if we have a request for an extension that remains the same process as last year. Let me turn over to the process for, or what I wanted to talk about in terms of in-service training. The requirement for in-service training, the annual in-service training, is spelled out in Chapter 6E, subsection 9B, and it directs the commission, the post-commission, to administratively suspend an officer who fails to complete in-service training requirements. We have corroborated a lot of this information and get updates continuously from the NPTC. This is something that is very much of very importance to the NPTC and of course to Post as well. And I will note that the requirement is on a fiscal year basis. They call it a training year basis, but it also ends on June 30th. And agencies have until September 30th to report the compliance with those requirements to the NPTC, again, by September 30th. So we are looking at the requirements or the compliance of fiscal year 22. This is June 30th of 2022. And we have seen that there's at least 46, it could be less, individuals that have not yet complied with this requirement. I will note that last December, we notified about 300 officers who were not in compliance, that this is an important requirement. And again, the NPTC routinely notifies officers who are not in compliance. We are taking steps now, given where we are in the new year, new calendar year, to administratively suspend individuals who do not yet meet this requirement. I will also note that the suspension is lifted or can be lifted as soon as the officer comes back to compliance. But this really should get the attention of individuals who have not complied with this requirement and ensure, well, that compliance is met. As of last night, we learned that at least one individual of those 46 actually did retire. So we are going to literally call or contact them directly to make sure that that's not the case. But in either way, in the next few days, we will take steps to administratively suspend individuals who remain out of compliance with this requirement. And finally, I just wanted to give you a brief update relative to our budget. Let me start with a brief history of the post expenditures and the funding that we have received. For fiscal year 22, we ended up approximately these are all figures that are approximate, about $2 million out of a $5 million budget reserve funding. We talked to ANF last year and others at Ways and Means in the legislature, and we were able to pack forward, is the term, or roll over $2.9 million last year into this fiscal year, and are on track to spend about $7.5 million this fiscal year, the fiscal year that ends this June 30th. In the last few months, we have discussed here and communicated to the administration that our fiscal year 24 budget needs to be at 9.1 million. This was approved at the commission in a prior meeting. And unfortunately, the House One budget includes 5.15 million for post funding. Our read is that that takes essentially the same level of the prior year fundings. Now, we've spoken with officials at ANF in the administration, and they understand that our need is indeed 9.1 million. They'll be looking at alternatives relative to covering that amount from perhaps other sources, as they tell us. But fundamentally, our next steps are to move to the Ways and Means, both the House and the Senate, to essentially discuss the needs for our 9.1 million, which we believe is still very much a very solid number, one that does not include a lot of padding, and we are on schedule to testify in front of them on April 4th of this coming month. I can pause there, Madam Chair. This is my last slide, and I can answer any questions on any of the topics I just, I'll do my stop share.
I think Commissioner Ellison has a question.
Yes, thank you, Madam Chair, and thank you, Enrique. Just a question on reporting as you were putting up. Are we able to cross-reference if a report is reported to a police agency now, and if someone from the public is reporting something regarding an officer, and seeing if they're in a timely manner? Are we able to cross-reference when those reports are coming in to that agency as well as to the post?
You mean a complaint, let's say, from the public,
Yes.
Commissioner?
Yes.
Yeah.
Yes.
Yeah. You know, we're getting a lot of information, Commissioner, that comes to both post directly and to agencies, and therefore agencies submit to us within the 2 business days that they're required to do that. We are hoping that the new functionality, we're relying on the new functionality that we will deploy on the portal that I just described to make sure that that process for correlation is a lot easier than what it is right now. in other words, with the help of technology. The number of reports and complaints that actually are coming from agencies are flowing into a general mailbox. And our new and improved process to be deployed later this year will flow directly into the portal that I was describing, which will simplify matters greatly. So I would say, Commissioner, that we are keeping up with reading those complaints, making sure that there's a follow-up, but I cannot tell you that we are completely sure that every complaint that has come to the agency has been submitted to post. We're relying on the agencies to comply with this requirement, and I don't have a reason to believe that they're not, but we have to rely on the agencies for reporting these complaints, the complaints that come directly to them. I don't know if I answered your question, Commissioner.
Yeah, just a quick follow-up. So if we receive a complaint at the post and we don't have that from the agency, is there a follow-up to find out why? Oh,
yes. So the public can certainly submit a complaint directly to post, and we read and follow up on each of those. That has us quite busy. We speak with those individuals. Often they want to just make sure that they are heard and we're following up, and where we need to, we do follow up. And we make sure that that agencies know about those complaints. I don't know if I misunderstood your initial question.
No, thank you. You cleared it up. Thank you.
Yeah.
And I think Commissioner Bluestone has a question, Enrique.
Thank you, Madam Chair. Enrique, my question is just about those individuals who may face administrative suspension. I'm just wondering about the availability of in-service trainings to bring them back into compliance.
We are told by the MPTC that that's always available. There are, I forget if that was last year because of the pandemic, but a lot of it was online. I don't know if I have my fiscal years mixed up. But in-service training typically is comprised of about 23 or 22 hours that the MPTC administers, and the remaining to the 40 hours is something that the agency administers. So what we're told, of course, by the MPTC, that there's no reason to claim that there's been problems with availability, and that there's always that, and they can always access even a few months into the new fiscal year, because people should now be doing their in-service training for this fiscal year. So yeah, we're told that there's availability, and we can follow up if there isn't, of course.
Thank you.
Thank you. Any other questions from my fellow commissioners of Enrique? Enrique, I don't see any other hands in the air. Thank you and the members of the staff very much for all the good work that you're doing and for the thoroughness of your report today. Let me move on and move to our General Counsel, Randall Ravitz, for a legal update, please.
Thank you very much. The first matter that I will address concerns the collection and utilization of information concerning uses of force, injuries, and deaths. And you just give me a moment. I'm unfortunately having some trouble opening the PowerPoint presentation that I've prepared. Let me see, let me try a different approach. All right.
Yeah, we can see your screen and the presentation, Randy.
Thank you. Okay, as I said, this is a presentation on the issue of collecting and utilizing information on uses of force, injuries, and deaths. Now, Chapter 6E, the Commission's governing statute, and regulations promulgated by the Commission and the MPTC jointly concerning uses of force provide for reporting by officers to their supervisors concerning various forms of information in this general category. So they provide that agencies must develop and implement policies and procedures for personnel to report uses of force, including incidents involving officer-involved injuries or deaths, and to report abuse by other personnel without retaliation. They also provide that each officer must complete a reporting form upon using force, and that if serving as an officer in charge, must report to the agency head or a designee regarding uses of force that result in death or serious injury. And that each officer must submit a report consistent with uniform protocols to a supervisor regarding another officer's excessive force. And they must report harassment, intimidation, or retaliation that they experience with respect to their own efforts to intervene when another officer uses force, or their own obligations to report uses of force. They need to report that harassment, intimidation, or retaliation to a supervisor. Then they also provide that agencies need to report certain information to the Post Commission and to a national database. Specifically, they have to report each death, serious bodily injury, and discharge of a firearm toward a person to the FBI-maintained National Use of Force Data Collection Database. And FBI guidelines call for various forms of data to be reported. I should note that they also recommend that law enforcement agencies provide information even for a month where there has been nothing that qualifies. There have been no injuries or deaths or firearm discharges. So in that way, there are times where it could help an agency to show that it has a minimal amount of such incidents. But the statute and regulations also provide for agencies to report certain information concerning their de-escalation efforts to the Commission when weapons have been used against a crowd. And these obligations, of course, are in addition to the duty of each agency to provide the Commission with a disciplinary record for each law enforcement officer and to transmit any non-minor complaint to the Commission and then indicate whether it alleges excessive use of force or resulted in serious bodily injury or death, and then to submit related and follow-up information, including reports as specified in the statute and regulations. Now, how would the Commission use such information? In other words, why does it matter that all of this is collected? Well, the Commission must review each report concerning the use of weaponry against a crowd. The statute requires that and states that the Commission may investigate further and shall, if applicable, make a finding about the conduct's propriety. So it provides elaboration regarding that specific type of report. But the Commission could also rely on reported information in making certification decisions, in initiating a preliminary inquiry and taking disciplinary action, or deciding to refer matters to other offices, such as prosecuting offices, for civil or criminal enforcement. The Commission could also take into account information that's reported to it in developing regulations identifying patterns of unprofessional police conduct, including those patterns of escalating behavior that may lead to the use of excessive force. So that's a form of regulation that is suggested in the statute, as well as other regulations and policies on the use of force in conjunction with the MPTC or other regulations or policies governing other areas. They can take into account this information in developing agency certification standards, which in part need to refer to the establishment and implementation of policies regarding use of force and reporting uses of force, and that would be in consultation with the MPTC. The commission could also look to such information as it maintains a database with information on complaints and related information, which has to include information on whether they involved excessive force or prohibited force or resulted in serious bodily injury or death. That's a statutory requirement. And in monitoring that database, another statutory requirement to identify patterns of unprofessionalism for which the commission, the Division of Standards, may recommend a preliminary inquiry. The commission also needs to submit certain information concerning officer-involved injuries and deaths to the legislature, the governor, and the attorney general. And in that report could identify any operational, policy, regulatory, or legislative recommendations to reduce the number and seriousness of officer-involved injuries or deaths. So it could take into account this information that's reported to it in developing that report. Of course, these are just things that are specified already in the statute and regulations. The commission could also develop other ways of utilizing that information, could analyze the information in other ways, make it available to the public in other ways. Now, a lot of this begins with collecting the information. And so officers, agencies, the MPTC, the commission would all benefit from the development of a standard form and process for reporting information concerning uses of force, injuries, and deaths. And that's contemplated actually by the use of force regulations. So at the staff level, representatives from the commission and the MPTC have begun working together, and we expect to continue doing so on this initiative, as well as other related initiatives regarding uses of force that we could talk about at another time. But one approach discussed recently is a form for law enforcement agencies that would remind them of certain obligations in this area that would be designed in such a way that it would facilitate electronic submission and analysis and reporting of data in interfacing with other databases concerning officer information. So in other words, it would be uploaded in such a way that it could be, that it would allow for easy analysis and easy reporting. And that would capture information on uses of force, including the use of certain weapons, on injuries and deaths, meaning of officers and members of the public, and in particular, that officers and information that officers and agencies are required to report internally or to the commission or to the FBI maintained database, as well as information that the commission is expected to maintain, analyze, or report itself, and information on specific forms of conduct that are referenced in statutory and regulatory provisions regarding the use of force. So, for example, using a chokehold, which is prohibited. So in other words, the form would provide a way, along with the instructions associated with it, of helping all of those participants in the process to satisfy their own obligations and to provide the information to each other. That concludes that presentation. We look forward to working more on this project and to updating the commission as it proceeds.
I think Commissioner Ellison has a question, Randy.
Yes, Randy, thank you for that presentation. Just a quick question. Is there any a statutory authority that authorizes the commission to audit agencies to make sure they're in compliance with these rules?
Yes, in fact, there is a statutory provision that requires the commission to develop regulations and promulgate regulations regarding audits of agency records related to complaints and so forth. And so that is something that's on our list of regulations to develop, and it provides for the audits to be conducted by the Division of Standards, but the statute also provides that the Division of Standards would have the power to conduct such audits of agency records at any time. So even without the regulations, the the division could do that. And that could be a way also to ensure that agencies are keeping the records that they're expected to keep.
Thank you. That would be my concern. Thank you.
Any other questions of Randy at this point? Thank you, Randy, for that comprehensive presentation. And I think you also are going to address proposed regulations, correct?
That's right. Oops. All right, let me just, this is it's the same one. I'm sorry for that. Just a moment. Okay, there we go. All right. This is a presentation concerning a proposed set of regulations that would govern initial certification of officers, as well as initial or renewed certification of independently applying officers. So in other words, officers that we've sometimes referred to as self-sponsored officers, as opposed to officers who are sponsored by or endorsed by an agency. And that would include constables. Okay, I just want to discuss the history of developing these regulations. At commission public meetings, as the commissioners know, protocols for initial certification and regulations on recertification were discussed thoroughly and approved over time. They were discussed, a combination of those two things, at 10 public meetings, a public hearing, and multiple less formal invitations for public comment between December 2021 and September 2022. And the reason I mention that is that those form the foundation for these regulations. These regulations are largely based on those. Then a presentation on issues involving constables was delivered at the October 13th, 2022 commission meeting. So it highlighted specific challenges in applying the certification process to constables. And then a draft set of regulations that these are based on was discussed without being formally presented at the November 22nd commission meeting. Now, outside commission meetings, staff from post-commission and the MPTC and EOPS have discussed issues and drafts regarding initial certification, recertification, constables, and other independent applicants, and these proposed regulations at various points over time. I think too many that it would be practical to try and list them, but that those same individuals have met or communicated with representatives of constable associations at various points of time, dating back at least to early April 2021 and continuing until this month. The draft regulations were provided to association representatives in early December of 2022. They provided some feedback in this month, and specific comments that they provided resulted in revisions that will be highlighted today. Just to provide an overview by way of reminder, again, these would govern any initial certification. So for example, certification of new academy graduates, and the certification of any officer who applies independently. That is, instead of applying with the endorsement of an employing agency, whether that officer seeks an initial or a renewed certification, and that group would include any constable. The regulations would generally apply the same standards and processes, as I said, that the commission adopted for the recertification process. And so I felt the need to say that twice. Now, that was just an error in drafting these presentation slides. But in the draft, the presentations regarding constables in particular are in boldface. That's just for convenience in discussing them. But there are also special provisions for independent applicants. Specifically, one question that arose is how would the certification standard of successful completion of a state national background check be evaluated for these applicants, given that normally we rely on an endorsing agency to take that step. So the regulations would provide that the applicant could either request that a law enforcement agency conduct one, for which the agency may charge a fee, or request that the commission conduct one, for which it would charge a fee. Another issue is, how would the certification standard of a successful completion of an oral interview administered by the commission be evaluated? How would the interview even be conducted when these applicants are not sponsored by an agency? And the answer in the regulations is that the commission would arrange for it to be conducted by one of several approved individuals and could prescribe the asking of certain questions, the covering of certain topics, or the use of a questionnaire, as it does now. Another issue that arose is, how would the certification standard of character and fitness be evaluated for these independent applicants? And the regulations would provide that the commission would make an assessment based on certain information collected in the process, including 3 professional references, one of which would need to be from a certified officer, and a set of guidelines that is spelled out in the regulations, and that's based on protocols previously approved by the commission for other officers. And then there's a set of additional provisions for constables in particular. Now, one provision deals with the meaning of the term arrest. Since Chapter 6E extends to a constable executing an arrest for any reason, that raises the question of what would constitute an arrest for these purposes. Section 903(2), which provides definitions, aims to answer that question. And that is one of a few sections that have been revised since the last draft was discussed before the commission, and it's revised partly based on, but not entirely based on, comments received from the constable associations. And that revised section, I'll take it piece by piece. Of course, all of that, the definition of arrest falls under a heading that states, for the purposes of these regulations, unless the context requires otherwise, the following terms have the following meanings. And the reason I highlight that is that this would define arrest just for purposes of these regulations. Now, the first sentence would provide that an actual or constructive seizure or detention of a person performed with the intention to effect an arrest and so understood by the person detained, that is an arrest. And that comes straight from Massachusetts case law defining the term arrest. The next sentence would elaborate on that. Again, since the first sentence refers to a seizure, that raises the question of what is a seizure under Massachusetts law. And so the second sentence aims to elaborate on that, and it states, for purposes of applying this definition, the following shall constitute seizures. And the first clause says, an application to the body of a person of physical force that objectively manifests an intent to restrain. And that's derived from a 2021 US Supreme Court decision concerning seizures involving physical force. So it clarified the meaning of a seizure in that context. The second clause would say that a seizure includes a show of authority through words or conduct that a reasonable person would consider coercive. And that's derived from a recent Massachusetts Supreme Judicial Court decision, which concerns seizures of that type and clarified that area. Then there's a third clause that says an exercise of the powers of constable that is facilitated by the use or display of a weapon. Unlike the other two clauses, that doesn't come straight from a case. However, there are federal and state decisions, quite a few of them, that make clear that the use or display of a weapon is something that militates in favor of an action being found to constitute a seizure as a general matter. And the commission has previously expressed the view when it discussed the scope of Chapter 6E and how to interpret this phrase, executing an arrest. It expressed the view that the carrying of a weapon should bring a constable within the scope of the statute. So this essentially brings that concept into this definition. Also, while the cases in this area, they don't say that the use or display of a weapon automatically makes something a seizure. They say that it's a factor that militates in favor of an action being found to constitute a seizure. There is a need in this case for a bright line rule, a rule that can be applied in advance of action by a constable so that they know and we know before they make that first arrest whether it even would constitute an arrest and whether they would be governed by the statute, whether they would be prohibited from doing it. So it wouldn't be practical in this context to say simply that it contributes, using weapon contributes to something being found in arrest, or that we'll evaluate it after the fact based on the totality of the circumstances. It seems necessary to phrase things in terms of a bright line rule. So that's why that clause is drafted that way. Another option would be to add that an arrest also includes any service of a capias or arrest warrant. There are some things that can be cited in support of that proposition. However, that's not included in this definition at this point. It could be added by the commission, but it's not included because the authority for that is not as well established as it is in those other areas. And also because even though the regulations say this definition of arrest applies only to these regulations, I do have some concern that someone might look at this definition and apply it to other areas beyond what the commission intended. So that's why the definition of arrest doesn't take that extra step. But again, that's up for discussion. Now, the next issue regarding constables in particular is how could it be established whether a constable will be subject to Chapter 6E and commission regulations before the constable executes their first arrest? In other words, that definition of arrest is helpful, but we still don't know who it is who plans to make arrests. And then what rules should govern the interplay between certification and the ability to exercise arrests? How do those two interact? So these regulations would provide that a constable who seeks to make arrests, who wants that power, could affirmatively apply for certification. And then if they're certified, they would be deemed a law enforcement officer. They would come within the definition, they would come within the scope, and they would be subject to Chapter 6E and commission regulations. They wouldn't acquire powers beyond those granted by other sources of law. So they would only have the power to arrest if there's something else that gives them that power. But they would be able to execute arrests, assuming that they do otherwise have that power. And then the regulations would provide that a constable who goes ahead and executes an arrest without being certified or without having the power to do so under law, they would still be deemed a law enforcement officer subject to Chapter 6E and commission regulations because it extends to a constable executing an arrest for any reason. So they would be brought within the scope of the legal process. But at the same time, they would be in violation of that those legal provisions because the regulations include a provision that preclude constables from making arrest unless they are certified and otherwise have the power to do so under law. So when they execute that unauthorized arrest, they are subjecting themselves to the commission's jurisdiction and violating the commission's regulations at the same time. And then they could face consequences as a result under these proposed regulations. So then another question that arises regarding constables is how could they be made subject to obligations and consequences that are comparable to the full range of obligations and consequences that are provided for with other officers, including officers working for agencies. Chapter 6E makes officers subject to various restrictions, obligations, and consequences, and many of them apply without regard to whether the officer is employed by an agency. It just says an officer, for example, shall not use a chokehold. That applies regardless of where somebody works. But they also provide that police departments must take and refrain from taking certain steps in handling mass demonstrations, and that decertified officers will be barred from appointment or employment by an agency. So then the question becomes, if somebody is not working for an agency, they don't even plan to work for an agency, how do we make them subject to things that are comparable so that they're in the same situation as other officers, and that the legislature's intent is fully realized with respect to them. So these regulations would provide that any constable who's deemed a law enforcement officer, in other words, anyone who's brought within the scope of the statute, whether they're certified or not, They would be subject to and thus need to comply with all the provisions of Chapter 6E and commission regulations that govern officers. And they would also need to comply with the provisions applicable to police departments in that section that I just mentioned, which deals with mass demonstrations. And they further provide that if that constable performs an arrest without certification or without having the power to do so under law, as I mentioned a moment ago, or if they violate Chapter 6E or commission regulations, they would be subject to decertification, suspension of certification, retraining orders, restrictions on powers, publication of these actions taken by the commission as with others, and fines. So in other words, even if somebody is not working for an agency, and so the threat of not being able to be employed by an agency doesn't have the same resonance with them, there would be other ways for the commission to ensure that they comply with their obligations and they don't violate the statute or regulations. Now, another question that arises is how could constables be subject to supervision comparable to what's expected for officers employed by agencies? Chapter 6E provides for officers to be overseen by and investigated by and reported by supervisors with respect to matters such as alleged misconduct and uses of force. And there are provisions throughout that make that clear. So the regulations would provide that in order to be certified, a constable would need to have a supervisor. Now, formally, the regulations use the term monitor, but the constable associations thought that that had a pejorative connotation, so it was changed to supervisor, which is a term that's used in the statute. And this individual, or this entity really, would need to be a municipal executive or a municipal law enforcement agency that agrees to serve and that designates one or more individuals who would then take personal responsibility for overseeing the constable and taking the steps that Chapter 6E requires of supervisors. So in other words, the same steps that the supervisors of other officers are expected to take. Now, Section 914 was revised based in part on comments received from the constable associations. And so that regarding who can be a supervisor, it now would provide that to qualify, an entity needs to be either a municipal executive or the principal law enforcement agency for a municipality in which they desire to serve. So in other words, whether they're elected or appointed, either way, one of those entities could serve as the supervisor. But at the same time, an agency that's barred from serving as the supervisor by the municipal executive, that in that case, the agency couldn't serve. So in other words, as compared to the prior draft, it broadens the range of possible supervisors. So it allows elected and appointed constables to seek supervision from municipal executives or municipal law enforcement agencies. They have more options. But at the same time, it reflects respect for the ability of a municipal executive to exercise control over who serves. So in other words, if the municipal executive said, we want to reserve the ability of ourselves to be the supervisor, we don't want the law enforcement agency doing that for whatever reason, they would have the ability to make that decision just as a matter of local control. So it's a respect for the ability of municipalities to decide who performs this role for the municipality. Now, the supervisor, again, would need to designate one or more individuals to perform certain responsibilities. They would include obtaining periodic reports regarding the constable's exercise duties, receiving reports regarding the uses of force, taking steps to ensure that the constable complies with their obligations, investigating alleged misconduct, reporting allegations of misconduct and failures to complete in-service training to the commission, and making records available for audit or inspection. These are the types of things that the statute and regulations expect of supervisors with other officers. And a law enforcement agency or officer who serves in such a role, because they're subject to the commission's jurisdiction, they would be subject to discipline if they agree to take on that role and then they don't do it. So that concludes that presentation regarding these proposed regulations. Happy to answer any questions that anyone may have if that's acceptable to the chair.
Yes, it is. Thank you very much, Randy. for that very thorough presentation. Do any of the commissioners have any questions at this point? Yes, Commissioner Luma, please.
Yeah, I just have a clarification question in regards to the supervision of constables. Now, is that for those constables who were operating independently, was that typical for them to have supervisors? Or is this, does the infrastructure exist for those individuals to find supervisors, and like, are there guidelines around how to do that?
Well, for appointed constables, they could be subject to the supervision of their appointing authority. Regarding elected constables, there's not necessarily anything comparable to that. And then even with regard to appointed constables, there's variation among, or the possibility for variation among different municipalities because it's a local matter. So for a lot of constables, this would be something new. This would be something that they would have to line up that they didn't have to line up before. But the alternative would be that all other officers, law enforcement officers throughout the Commonwealth are subject to oversight and supervision by someone who can investigate them, who could file reports, who could discipline them. But this group wouldn't be subject to any supervision. They would be on their own. So it's really, it's intended to put them on a par with other officers and make them subject to the same type of oversight that other officers have.
But so with other authorities, their supervisors are also law enforcement, and they get the same level of training the supervisors are required to get the same level of training as the officers. For those constables, are there any requirements that we're going to establish for those supervisors who are providing the monitoring or supervision of those officers? I think there's a bit of a disconnect. I'm just trying to understand what's the expectation of the supervisors that we're asking to provide the monitoring of those constables.
It's a very fair question. So one of the alternatives is for the supervisor to be the local law enforcement agency. So if that ends up being the supervisor, those people would have the training. Those people are accustomed to being subject to this whole system. But if it's another alternative is that it would be a municipal executive, like a board of selectmen, a town manager, a town administrator, and that was based on the thinking that that's the appointing authority, or often will be the appointing authority, maybe not always, but of the constable. But I will concede, Commissioner, that the regulations right now don't include anything that would basically provide for those civilians to be trained in a way. So I think that's a very, fair concern that you raise, and it is something to consider.
Thank you.
Thank you. Any other questions from the commissioners? Don't think I see any hands in the air. May I, at this point, turn to Enrique, and we are not taking questions from the public today, but Enrique, could you please explain to those members of the public in attendance how they can comment on what Randy has just gone through?
Thank you, Madam Chair. And yes, we're not taking comments. I have seen some activity on the Q&A function, which is not disabled, and where we can try to just answer to them. That we can take, as usual, we take comments from our general mailbox, from our individual contact information that's available on our website, and we'll continue to remain responsive to all those questions.
Thank you. Any other comments or questions from commissioners on anything relating to what our general counsel has presented? And I don't think I see any other hands in the air. Thank you once again, Randy. Let me move on to the next matter on the agenda, which is whether there are any matters not anticipated by the chair at the time of posting. The answer to that question is negative. And I would now mention that I will entertain a motion to go into executive session in accordance with the provisions of General Laws, Chapter 30A, which address anticipation of discussion regarding the investigation of charges of criminal misconduct, the provisions of that statute, along with Chapter 6E, Section 8C2, and to the extent to which they may be applicable, Chapter 6 and Sections 168 and 178 of that chapter, in anticipation of discussion regarding the initiation of preliminary inquiries and initial staff review related to the same and regarding certain criminal offender record information, and Chapter 30A, Section 21A7, and Chapter 30A, Sections 22F and G, in anticipation of discussion and approval of the minutes of our last executive session. Is there such a motion?
So moved.
Is there a second to that motion?
Second.
Let me then ask Commissioner Bluestone,
Yes.
Commissioner Calderon,
Yes.
Commissioner Sherry,
Yes.
Commissioner Ellison,
Yes.
Commissioner Gazarozian,
Yes.
Commissioner Luma,
Yes.
Commissioner Wynn,
Yes.
and I also am a yes on that. Let me state for members of the public that we will not resume the public meeting after our executive session. So I think with that, unless there are any other matters, we will conclude this open meeting. Thank you all for attending. And commissioners, we will go into executive session in approximately 5 minutes. We'll take a brief recess. Thank you all again.